Hello friends, in this video, this is part 2 of my earlier video. Earlier video was on dying declaration. In the earlier video I explained the sections, and in this video I thought some case laws should be given so that you can understand the dying declaration, this provision, more clearly. The case law is on your screen. The Supreme Court in Amar Singh versus State of Rajasthan held that the cause of death of the deceased was a question to be decided, and the statements made by deceased before PW4 and PW5 that the appellant used to taunt the deceased in connection with a demand of a scooter or 25,000 rupees within a couple of months before the death of the deceased are statements as to the circumstances of the transaction which resulted in a death within the meaning of 32(1) of the Indian Evidence Act. So you got a nice example of section 32(1) of evidence. The question the cause of death of the deceased was a question to be decided, and the statements made by the deceased before PW4 and PW5. Deceased made the statement before PW4 and PW5 that the appellant, means the accused, here accused, this is an appeal case, accused used to taunt the deceased maker of the statement in connection with the demand of a scooter or rupees 25,000 within a couple of months before the death of the deceased are statements as to the circumstances of the transaction which resulted in her death within the meaning of section 32(1) of Indian Evidence Act. Now, the second one on your screen. The Madras High Court held that section 32 is an exception to the hearsay rules. In normal courts, we will study it later that hearsay evidence cannot be considered. But section 32 is an exception to it. Exception to the hearsay rules, and deals with the statements or declarations made by a party since dead relating to the cause of his or her death or the circumstances leading to such death. If a statement which otherwise is covered by the hearsay rules does not fall within the sub-exceptions of section 32 of the Evidence Act, the same cannot be relied upon for finding the guilt of the accused. In the earlier case, deceased made the statement before PW4 and PW5, and PW4 and PW5 stated it, deposed it before the court, that they heard from the deceased that she used to be taunted for the scooter or rupees 25,000. So if we consider it, the statement made by PW4 and PW5, these are hearsay evidence, but under section 32(1) it is relevant, so it will be considered. In this case law, it is clearly stated that if a statement which otherwise covered by the hearsay rules does not fall within the exception of section 32 of the Evidence Act, same cannot be relied upon. Now, I am coming to the next case law. Madras High Court again. Any circumstances which has a nexus with the death, proximate or distant, direct or indirect, can also fall within the ambit of subsection 1 of section 32 of the Indian Evidence Act, and it can be used as an evidence. Very clearly stated. any circumstances which has a nexus with his death. His means the maker of the statement. Proximate or distant, direct or indirect, can also fall within the ambit of subsection 1. Next, the Supreme Court observed that a dying declaration recorded by a police cannot be discarded on the ground alone. We know that statements made before police cannot be taken into evidence. Here is the exception. Is the dying declaration recorded by the police cannot be discarded on the grounds alone. There is no requirement of law that a dying declaration must necessarily be made before a magistrate. In dying declaration, there is no such mandate that it should be made before a magistrate. In normal course, statements made before the police cannot be taken into consideration. But if it comes under the exceptions of section 32, it can be considered. There is no mandate that dying declaration must be made before a magistrate. Next case law. Supreme Court. It cannot be laid down as an absolute rule. Listen carefully, minutely. It cannot be laid down as an absolute rule that a dying declaration cannot form the sole basis of conviction unless it is corroborated. It cannot be laid down as an absolute rule of law that a dying declaration cannot form the sole basis of conviction unless it is corroborated by some other evidence. Each case must be determined on its own facts, keeping in view the circumstances in which the dying declaration was made. The circumstances will vary case to case, and the circumstances should be considered. It cannot be laid down as a general rule, general proposition that a dying declaration is a weaker kind of evidence than other pieces of evidence. It is not that dying declaration are a very weaker piece of evidence. No. A dying declaration stands on the same footing as another piece of evidence and has to be judged in the light of surrounding circumstances. Again, the court mentioning the word circumstances and with reference to the principles governing the weighing of evidence. Fine. I am coming to the next case law. Supreme Court. It is well settled as a matter of law, a dying declaration can be acted upon without corroboration. In earlier, it is said, observed by the court, that it may not be corroborated, and now court made it specific that a dying declaration can be acted upon without any corroboration if it satisfies the other features. Again, Supreme Court, there is not even a rule of prudence which has hardened into a rule of law that a dying declaration cannot be acted upon unless it is corroborated. So, corroboration of dying declaration is not a mandate in law. The primary effort of the court has to be find out whether the dying declaration is true. Court should try to find out whether the dying declaration is true. If it is true, if the court finds it to be true, no question of corroboration arises. It is only if the circumstances surrounding the dying declaration are not clear of convincing that the court may, for its assurance, look for corroboration of the dying declaration. So when corroboration is required, it is only if the circumstances surrounding the dying declaration are not clear of convincing. If the circumstances are not convincing, then court may look for its corroboration. Again, Supreme Court, a great solemnity and sanctity is attached to the words of a dying man, because a person on the verge of death is not likely to tell lies or to concoct a case so as to implicate an innocent person. Yet the court has to be on guard against the statement of the deceased being a result of either tutoring, prompting, or a product of his imagination. So, here the circumstances are explained. The statement of a person on the verge of his death can be either tutored, prompted by someone, or product of some imagination. But at the same time, it is not expected that a person on the verge of his death will not tell a lie to implicate an innocent person for the cause of his death. Again, Supreme Court held that the court must be satisfied that the deceased was in a fit state of mind to make the statement after the deceased had a clear opportunity to observe and identify his assailants, and that he was making the statements without any influence or rancor. Once the court is satisfied that the dying declaration is true and voluntary, it can be sufficient to found the conviction even without any further corroboration. So, here also the circumstances to verify the dying declaration is given. Next, again Supreme Court held that if the deceased made statement to the witnesses and their testimony is found to be reliable, testimony of the witnesses who heard the statement of the person died, if the deceased made statement to the witnesses and their testimony is found to be reliable, the same is enough to sustain the conviction of the accused. Again, Supreme Court held that the doctor who examined the victim was the most competent witness to speak about her condition. When court has to check the mental condition, mental state of the deceased who made the dying declaration, the doctor who examined the victim was the most competent witness to speak about her condition. Again, Supreme Court, on receiving message from the hospital that a person with gunshot injuries had been admitted, a head constable rushed to the place after making entry in the police register and after obtaining certificate from the doctor about the condition of the injured, took his statement for the purpose of registering the case. It was held that the statement recorded by the head constable was admissible as dying declaration. Very nice example to understand the provision. A head constable found an information from the hospital that a person with serious gunshot injury admitted to hospital. Immediately the head constable recorded the matter in his official record book maintained in his regular course of business, and went to the hospital, met the doctor and took doctor's opinion about the mental state of the victim, and thereafter recorded the statements of the victim for the purpose of investigation. It was held that the statement recorded by the head constable was admissible as dying declaration. Again, Supreme Court, it was held that the failure on the part of the medical men to record the statement of the deceased in question and answer form cannot be in any manner affect the probative value to be attached to their evidence. So, it is not necessary that the dying declaration should be in question and answer form. It can be a thorough statement only. So there is no specific format for dying declaration. I think these few case laws which I thought will be helpful for you to understand the provision of dying declaration will be helpful for you. I will be very happy if these videos become helpful for you to understand the provisions of Evidence Act. I will request you to kindly subscribe and share these videos if you like it, and if you have any question, any doubt in your mind, feel free to write to me or telephone me in the given number on your screen. Thank you very much for watching this video. Stay safe.